designed for situations of danger. So you have to bear that in mind when you decide how much you're going to allow somebody legally to deviate from that. Okay, so that's the basic ethical package. Okay, now in my view, there are ethical reasons why that ethical package has to be foregrounded in your legal analysis and your advice to the government. In other words, you can't, what these torture memos do is never take account of how important in our legal system the prohibitions on torture are. They don't take account of that. And my point is that you are ethically required to take account of it in a very serious way because it is so fundamental. Now, there are two kinds of reasons why you're ethically required to take account of it in your legal advice. One is to avoid harm to your client as a result of your legal advice. If I say, yeah, go ahead, and then you end up being prosecuted for criminal behavior. If I say, yeah, go ahead, and then there are political and practical and international backlashes. If I say go ahead, and then the cost of your making yourself accountable for what you did becomes very high, I have done you harm if I didn't give you a balanced legal advice. Similarly, if I don't, in order to avoid harm to you, you're my client, you are the president, you're the vice president, you are the head of the CIA, you have massive responsibilities to the public and for the public's safety. And in order to, and you have responsibility to the constitutional tradition and to political constituency. You've got huge responsibilities. So what I have to do to make sure that I don't harm you by narrow-minded legal advice is to tell you what the range of options are and what the range of risks are and what the range of possibilities are. In order for you to meet I'm talking about the client, your public responsibilities, your official responsibilities. So again, for the lawyers who are here, this is like the requirement that doctors give a full explanation to a patient of the risks and the options in order that the patient can make an informed decision. And that's what the lawyer has to do, I say, to avoid harming the client in this situation where the stakes are so high and fundamentals of the legal system are at stake. Now, there's another reason why the lawyer, I think, is ethically required to emphasize these fundamentals in his legal advice, and that's because the lawyer justifies his behavior as a lawyer on the basis of the value and virtue of the legal system. You give legal advice to crooks. You help crooks get off. You help polluters get off. You lobby for tobacco companies. Whatever it is that you're in your particular list of atrocities, lawyers do it. They represent all these atrocious people, and they help them. They help them win. They help them make money at your expense, and so on. Now, most people would say, well, you're not supposed to do things like that for bad people. Well, in the legal system, you are. And the reason is that the argument is that if everybody gets good representation, the system will produce the maximum amount of justice. Now, if you believe that as the way that you justify your own behavior as a lawyer, then you have, at the same time, to make sure that the system actually works so that it does maximize justice. And one of the ways that you do that you have to do that, is to protect the premises, the personhood premises of the system itself. If you don't live up to the premises of the system, there's no way that you can claim that it's going to produce justice. And if it doesn't going to produce justice, then you can't justify your behavior on the basis of it. So there are also process reasons of ethics why these issues need to be included in the analysis. There are reasons of, one of the kinds of basic ethical processes is generalizing. And that means, in this case, using analogies, using this law of emergency that I was talking about, which requires you to look at the immediacy, the clarity, and the degree of the threat, and requires you to evaluate in the circumstances the effectiveness of the means you want to use. And you've already heard how coerced confessions are unreliable. It requires you to look and see whether there are alternative ways of reducing the threat. It requires you to have time and scope limits on the state of the emergency. So all of those analogies, they're going to cut against extreme coercion. There are also, lawyers also, the part of their stock and trade is the building of institutions of self-correction and trust. They do this in the Constitution with checks and balances. You do it in corporations. You do it in trusts themselves. And those institutions of self-correction that would be relevant here are limits on secrecy, requirements of objective auditing, consultation by the executives who are operating. So those are all ethical, that's all generalizing as a way of trying to come up with legal analysis here. Then there is generalizing in the form of gaining perspective from similar circumstances. And we've had the Japanese relocation, we had the Communist Party hysteria, anti-communist hysteria. And the lessons from those emergencies were, I think, that you got to have some historical perspective. Things can be very, very scary, but it doesn't follow that you have to treat scary situations as apocalyptic. And I think those are lessons from those historical periods. And then there's the issue, the point of consulting widely and diversely. That's a form of generalizing. And what happened in the Bush administration was a great deal of unilateralism and impulsiveness. Then the lawyer has to exclude his self-interest from influencing his legal advice. That's also an ethical process. And that means when you're working for people at the pinnacle of power, you've got to put controls on your ambition and your desire to please them. It means you have to limit your identification with the client. In Enron, the lawyers were economically in bed with their client. Here, the author of one of these memos was a member of a war council where the top-level lawyers and executives figured out what their strategy would be about interrogation. And of course, a lawyer can give advice, but you can't then pre-commit yourself. If you're then going to give an opinion letter that's supposed to be like a rule of law on these proposals, you can't have been so involved that you've pre-committed yourself to the answer. And then, of course, you have to be careful not to import your political values. And in the case of these memos, the argument in favor of the commander-in-chief's power was so outside the legal framework that it was really a political value. So now I'll just quickly summarize then what an ethically constrained legal advice would look like. I think would be it would fully face up to fundamental values of personhood. It would lay out the range of moral and legal risks in radically departing from established law and analogies. It would lay out the options and try not to foreclose the client's range of choices in exercising his responsibility. It would stress the limits of emergency law. It would suggest safeguards and objective controls on what the government proposes to do. And it would use cautionary history. And it would be aware of the need for law-abidingness that was captured by Justice Brandeis when he was a practicing lawyer, when he said, "I don't know where the line is, but I can tell you when you're getting close to it." Now, I don't mean to say that these torture memos couldn't give the client the arguments that they could make for their side. And I think that's important. If the client is the President of the United States and he says, "I've got to do this for the safety of the country," you can't say, "Oh, I'm not even going to tell you how to do it." You can give him advice within as long as it's credible, but it has to be put in the context of these ethical constraints, in my opinion. And if you're under horrendous time pressure, as I am to finish this so that Bill Roller won't get mad at me, you can do it briefly, but you've got to do it.